Good morning, and welcome to Zicklin Talks Business. I'm Bruce Weber, Willem Quaker Dean of the Zicklin School of Business, and I'm delighted to have you with us for today's timely and thought-provoking conversation. In recent years, corporate leaders have increasingly spoken out on political and social issues, from Elon Musk's editorial decisions at Twitter X and clashes with regulators, to Jamie Dimon's commentary on political candidates and income inequality, to Tim Cook's advocacy for strict privacy for technology users and LGBTQ plus rights. These statements shape public discourse and at times move markets and companies' share prices. But do they also raise legal and ethical questions? Can expressions protected under the First Amendment risk breaching fiduciary duties to shareholders, especially in Delaware, where most U.S. companies are incorporated, and where directors and company officers are bound by law to act in the company's best interests? Today's webinar explores the tension between free speech and fiduciary responsibility. Our moderator, Larry Zicklin, class of 1957, will guide a conversation with two distinguished guests. First, Norman Dorsen, Professor of Civil Liberties Emeritus, NYU Law School, and founding legal director of the Brennan Center for Justice at NYU. He's a leading civil liberties advocate and served as national legal director of the ACLU and special counsel to the National Organization for Women Legal Defense Fund. Professor Neuborne has argued numerous Supreme Court cases and litigated hundreds of constitutional matters. He's received NYU's Distinguished Teaching Award, been elected to the American Academy of Arts and Sciences. His most recent book is Madison's Music on Reading the First Amendment from the New Press 2015. Our second panelist, Paul Roth, is founding partner emeritus of Schulte, Roth, and Zabel. He served as counsel to leading public and private companies in financial services and to their boards of directors. He's advised hedge funds and broker-dealers in connection with regulatory matters and acquisitions. Paul is currently adjunct faculty at the NYU School of Law and is taught at the Wharton School at University of Pennsylvania. We reserve time at the end for audience questions. Please submit those via Zoom's chat feature to my colleague, Associate Dean Gwendolyn Webb. And now I'll turn it over to Larry Zicklin, former CEO and chairman of Neuberger Berman and a valued member of our MBA and undergraduate honors faculty. Larry, the floor is yours.
Thank you, Bruce. Appreciate it. And it's nice to talk to old friends, Burt and Paul, whom I teach with at NYU. Anyway, like everyone else, corporate executives have rights of free speech, but they also have fiduciary obligations under Delaware law to protect and enhance the value of the corporations they serve. Since the two of you have such long experience in corporate affairs and free speech, I have to ask, are those two sentences contradictory? Free speech and fiduciary responsibilities. Burt, you want to try that?
Sure. I don't think they're contradictory at all. I think they accurately describe a tension that exists in any complicated world where individuals have both the right to speak, but also obligations to people with whom they are closely associated and whom they can harm if they speak. And how that tension is worked out is itself a very complicated idea. There's an assumption, and there's sort of an assumption that underlays what a lot of us think of, and somehow that's going to be worked out by law, that somehow Delaware is going to pass a fiduciary obligations law, or the First Amendment is going to stop them from doing it. I think we overstate the degree to which law plays a role there. I think we'll talk more about this, Larry, but I think personal ethics and peer pressure probably have more to do with what corporate executives can say than either the First Amendment or the Delaware Chancery Court.
Paul, do you want to react to that?
Well, I think that's right. And I think Burt puts it very well. I remember reading a long time ago a book about Harry Truman when he was ascending to the president. The question was, does the man make the president the office, or does the office make the man? And I think there's a little bit of both in it. in the response. But a fiduciary, a CEO or senior member of the management team of a company is first limited by what that fiduciary thinks is appropriate and his ethical standards or her ethical standards. That's the first sort of sphere of limitation or self-limitation. The second is this sense of, well, it's appropriate in connection with what? Not necessarily what I think, but what if I am somebody who stands for the corporation in the public eye, and I can't be disassociated from it. I can't say this is my personal view because it doesn't work. So what you have is a sense that your fiduciary duty requires you not to hurt the business of the corporation and especially not to hurt what the corporation stands for in the public mind in terms of what it thinks is the right thing to do. And it's an act that requires some balancing, but it's not an impossible thing to do.
Well, this came into being in my own mind when Elon Musk was so active in Doge and in Republican politics. And I'm going to assume right now, and this is an assumption, that Tesla sales, which went down a lot, both in the United States and especially in Europe, might have gone down because he offended so many potential Tesla buyers. Did he violate his fiduciary responsibility when he spoke out and was so vehement in Doge?
Well, I think, Larry, the first question would be, you have to ask Musk himself what he understands his own personal ethical obligations are, because that's where the first question was, were you true to yourself? Were you true to the person who you want to be and who you think you are? And
I'm going to assume he believed everything he said.
Well, no, you can, I mean, I seem to have gone dark here.
No, you're fine.
I'm fine?
Yes.
Okay. Well, I've lost the visuals, so I'm going.
We can see you fine.
Fine. My sense is that in my own life, when I think about my own life, I mean, I've made judgments in my life that I wish I could take back, that I thought were correct when I did it, but time has passed and I realized that maybe I didn't live up to the person I hoped that I would be. So that's the first question you'd ask Musk. Are you sure that you're behaving the way you really think you should? Then the second set of pressures that could be brought to bear on him are peer pressures, people that he respects and cares about. Do they think he's hurting the company in ways that are self-indulgent and willful? And that could bring to bear some pressure on him. Then I would look to see what his contract says with the company. Does the contract, did he sign a deal like this $1 trillion deal? Paul and I were talking about it. This $1 trillion deal he got. Is there a clause in there saying that you got to stop saying things that hurt the company? And if so, could that contract be enforced in a way? And I think the answer is the contract could be enforced. And then only then I ask, are there legal things that has Delaware imposed a fiduciary duty on you that some sue you about? Is the government going to take away contracts that Tesla needs or Musk wants? Is he going to be sanctioned by the government? And finally, is the government going to punish him? It's only if the government is in the sentence that we talk about the First Amendment. Otherwise, we're talking about private people organizing their lives in ways that are both ethically important to them and ethically important to the ethically and in terms of values important to the people they deal with. And law doesn't play a role in it. I hate to say it because Paul and I have made a living by saying that law is very important, but law doesn't deal with everything. Individual ethics deals with a huge amount of what's important in the world.
So the First Amendment protects you against an imposition of restrictions on free speech by the government, but
Only
not by the corporation.
Yeah, only the government does. The First Amendment has nothing whatever to do with the behavior of private people, and that's corporations, your wife, your friends. That's entirely outside of the range of the First Amendment. It's Congress shall make no law, and no state shall interfere. It's not individuals.
Paul, you've advised many corporations in your career. If Elon Musk had come to you and said, I'm joining the administration, I'm going to be a kind of ad hoc member of the administration, and I'm going to be doing all this Doge work, and what would you have advised him?
Well, first of all, I guess I'm counsel to the corporation, right? So
Yes.
I would be advising the board, not Elon Musk. I'd probably advise the board decide whether they think it's appropriate for him to do that. And as a matter of fact, we were talking earlier today about the fact that the board has offered a $1 trillion bonus to Elon Musk over 10 years if he meets certain very formidable targets in growth of the company. I would say to the board, look, you cannot separate Elon Musk, what he says, from what Tesla says.
Even if Elon Musk says, I'm talking right now just as a human being, not anything to do with Tesla.
That's right. It doesn't work. It's not like you can do, for example, if a faculty member speaks freely about an opinion of a course that he teaches or something else, the dean of the school can say that faculty member is voicing his own opinion. It is not the opinion of the school. They're just too close. I mean, it's as though you have Steve Jobs at Apple trying to separate Apple from Steve Jobs. He was the founder of Apple, and you couldn't separate them. They were. So I would say put a clause in his contract. He's going to possibly earn $1 trillion that he can't speak publicly without consulting with the board about matters of public policy. He can speak about the operations of the company, but we don't want him to speak about public policy. Now, Burt and I were talking. Burt advises that would be legal if you have a contract with a specific individual under these circumstances. It would not necessarily be legal if, no matter who it was, anybody who works for the company can't say anything, but I'll leave that to Burt. It's an important distinction because this is a private contract between the board, company, and Musk.
Yeah.
And go ahead, Burt.
Paul, I didn't mean to interrupt. I thought you would keep going.
That's okay. Go ahead.
No, I would say that I agree with you. As a legal matter, the Supreme Court's drawn a bright line between enforcing contracts, and this is a sort of interesting legal story. The Supreme Court says the enforcement of a contract, of a volitional deal that parties make with each other, is not state action. That all the state does under those circumstances is assist the private individuals in carrying out the arrangement that they had made voluntarily without the state. So if you enforce a contract that prevents somebody from saying something, that's not state action. And that has to be right, because it can't be that if somebody makes a contract to buy the New York Times, and then the New York Times gets cold feet, and then someone sues to enforce that contract, The Times can't come into court and say, my God, the state is taking away my newspaper. It's violating my free speech rights. It's the enforcement of a volitional deal is not state action. State action is when the government imposes the sanction on you, whether or not you agree with it. And that's the difference. The lawyers will tell you that's the difference between contract and tort. Tort is when the government imposes obligations on you. Contract is when you make the obligations up yourselves between the two of you. And contracts.
Let me, if I test your use a hypothetical to test the boundaries that you're talking about.
Cool.
Suppose Mr. Musk says something that the government doesn't like, the administration doesn't like, and the order is put out, we're going to take away any tax incentives to buy electric vehicles. And that demonstrably hurts the sales of Tesla. Now you have a government intervention with a private contract.
Yeah. Now,
how does that those two things intertwine?
Yeah, now you've changed the legal landscape, because now you've moved from a purely private deal to a situation where government is using both the carrot and the stick. It's using inducements and it's using threats to try to get the parties to behave in a particular way. And that crosses a really important legal Rubicon. At that point, it's state action. It's the government acting. And in fact, that's what we're seeing today. That's the explosion of a very powerful president using all of the powers that are at his disposal to try to induce people and frighten people to say and speak and act in particular ways. And that raises profound First Amendment arguments. They are the hardest First Amendment arguments. The easiest First Amendment argument would be if the government moved in and just arrested Musk and said, "Don't like what you're saying. You've harming national security." They lock them up and they put them away. That's what the traditional First Amendment deals with. It deals with government sanctions, directly imposed government sanctions. In the modern era, government has gotten much more sophisticated, and instead of censoring people by locking them up, they censor them by removing very important benefits that government provides them. Whether in the earliest case, it was a tax exemption, real estate tax exemption in Los Angeles, in the city of Los Angeles. And Los Angeles said back in 1957 that you can have this real estate tax exemption, but you have to sign a loyalty oath. This was during McCarthy. And you have to sign a loyalty oath opposing communism. And this guy wouldn't sign the oath. So they wouldn't give him his tax exemption. And the Supreme Court held that you can't condition a government benefit on the waiver of a First Amendment right. It's called the unconstitutional conditions doctrine. And I think, Paul, that's what would happen with your hypothetical.
Did we have this kind of recently in Florida, where Disney took a stand that the governor didn't like, and he retracted a tax exemption from Disney on the Florida law?
Yeah, Disney.
This was the "Don't Say Gay" case.
Yeah, if you can remember, if you remember back that far, when Disney had Spine, that's when Disney had some fight in them, and they fought back and they sued. And if they had continued that fight, if they had really, not rolled over and decided that it wasn't worth the trouble, they probably would have won. Now, of course, you never know. You have to prove the facts. You never know what the threats were and how strong they were. And but that's exactly, Paul. That's exactly what the Disney case was. It was a test case on unconstitutional conditions. And Disney eventually decided it was in their best interest to pull back.
Paul, in your examples before, you used Elon Musk and you used Steve Jobs. Are the conditions different if it's just Sidney Glotz that manages XYZ company? He's not particularly associated with it. After Glotz will come somebody else, and before Glotz there was somebody else. Is there a difference between Glotz and Musk and the requirements of each?
I actually think there is. I mean, I think that the identity between the CEO and the company in the public mind imposes greater fiduciary duty on the CEO, make sure his statements are disassociated with the company stance. And I think you can do it. I don't know company XYZ or Sidney Glotz, but I take it you do, since I've heard you talk about him many times before.
Oh, he's a very good friend.
Yeah.
But I think there's a difference. I think there's a difference. Public perception.
So you're saying to me that Elon Musk has more responsibility, let's use Delaware law for just a moment, even though Tesla's now incorporated in Texas, under Delaware law than Sidney Glotz has for his company, both of which are public.
Yeah.
No.
Well, that's close.
I think Paul's right. They have different obligations, but I don't think they're legal obligations. I think they're ethical obligations. Glotz and I were bar mitzvahed together, so I've known him a long time. And Sidney would not violate his ethical obligations. But if nobody knows, nobody associates him with his company, then if he says something, then there's no reason to think that he's violating any kind of, that he's harming anybody else.
I have to disagree with you, Burt. Sidney cheated at stickball in Brooklyn.
Well, that's true. That's true. Sidney could never hit.
Right.
Okay. And is there a difference between a publicly held and a privately held company? If a company is owned by 50 people that happen to contribute, but it's not public, and is a public company with 500,000 shareholders, is there a difference in their obligations?
I think there is, but it's not a legal difference. Again, it's how you hold yourself out, and under the law, you have the same fiduciary responsibility to the corporation.
Yeah.
It's just that the way in which you're identified with the corporation is going to be more attenuated as a private company than a public company in most instances. Not in every instance. There are public corporations that are clearly identified with their CEO, and there are private corporations that are clearly identified with their CEO. So the concept remains the same in terms of fiduciary duty and how you, as a person, conduct yourself so as not to harm the company which is you're representing.
Yeah, I agree with Paul that although I think there's an irony here, I could imagine a closed corporation, maybe family owned, maybe owned with a relatively small number of people who are intimately connected with each other. And if I were the president of that corporation, I might feel a stronger ethical duty not to harm the lives of my close friends and associates than I would feel toward the potential for harming this, creature called a corporation where I don't know anybody who owns the stock and I don't know anybody in the deal, but I don't know that I would feel the same sense of personal loyalty to them. Maybe I should. Maybe that's an interesting question that you guys who live in the corporate world have thought about. But I've always wondered whether there was a difference in the sense of personal duty that the owner of a small, intimate group feels. I'm not necessarily saying that this is the Elon Musk model. I'm talking of the Stanley Glotz model, where I just own an ordinary corporation and it goes out and does things, and I'm not particularly associated with it. I'm not sure I would think that there was much of an ethical duty for me to shut up. But if it was a group of my friends that had, pooled their life savings to do something, I would think a long time before I did something that would harm them.
But I think we need to point out, and I think you agree, Bert, this is a matter of your personal integrity,
Exactly.
your relationship. This is not a legal distinction.
Yeah, no, that's right. You're exactly right. There's no legal difference, but since I don't know, I'm sure this is the experience of both of you. Now that at the end of a very long legal career in which I've been in court all the time and argued about the importance of laws, I look back now. The decisions that made differences in my life and in the lives of people I know were personal decisions, ethical decisions, not decisions that were forced by law. Sometimes they're very important, but I think most of a society, the nature of a society is, I think, defined far more by the individual personal judgments of people rather than the legal norms that are imposed upon them by the state. And if you get into a society where the only norms that count are the state norms, then you've lost. Then your society is gone. Because if the only thing that matters is what happens to a bad man, then that society is on the way out. It's going to collapse. And that's why it's so important to have a discussion like this, to reinforce the importance of ethics as it stands apart from law.
So we're talking now about the imposition of limits on free speech by society. But even in the corporate world, to say nothing of the academic world, the corporate world, I don't think many people would speak out publicly without consulting the PR people or the HR people or somebody at the corporation. So is that person imposing limits on free speech? By saying, hey, I would rather you didn't talk about that because that would harm the corporation.
You mean the HR person who gives advice?
Yeah.
Sure, he's imposing a limit on free speech, but it's not an illegitimate limit. I mean, simply to have someone warn you, have you thought about the consequences of this? Are you really sure that you want to do the balance between, because don't forget, ethics also includes your duty to speak out. I mean, this is not a one-way street. If you live in a free society and you care about things, then you have almost a duty and share your views with your fellow citizens so that self-government can work. And if everybody silences themselves all the time because any negative consequence from the speech is thought to be enough to shut them up, then one, you don't need censorship. Private stuff is doing it even more effectively. And two, important speech dries up. And people don't hear things. So it's really when Paul calls it an ethical duty, and I think he's absolutely right. He'd be the first one to say that the ethical duty points in two different directions. One says that you have an ethical duty to speak, and the other one says that you have an ethical duty to think hard about the consequences of your speech. That's what makes it a hard judgment. But it's got nothing to do with the government.
And thinking. And thinking, I just want to make one comment. Thinking hard about what you're going to say, is that another way of saying, of thinking hard about not speaking?
Sure.
So here's the HR person or the PR person, whoever it is, says, don't you dare talk about that, because if you talk about that, it will harm the corporation, and I will recommend that you be fired if you talk about that.
I think that, let me give you an example, a real life example.
For some reason, you got an echo now, Paul. I don't know why.
I don't know why either.
Okay.
But I used to get calls from the press, and the calls from the press would ask me to comment on a case. If we were involved in the case, I would say, I can't really discuss that case with you because we are representing a litigant in that case. And even though I might want to do, it was inappropriate for me to do. As a matter of ethics, it would be inappropriate. Somebody could use what I might say against our client. I would, however, comment on cases that involve issues of law that we were not involved with. So the journalists knew that I might speak about something, whether it was a 10b-5 violation or not, and give my interpretation as a member of the bar. But I would never speak about a case in which we had a representation in a litigant. And as a matter of fact, we get emails from management of the firm saying this case is receiving a lot of press. If you get an inquiry regarding it, please refer the inquiry to so-and-so. I don't consider myself as having my speech interfered with. I consider that part of being a lawyer and acting within ethical bounds.
Yeah, and I'll bet if I pushed you on that, the ethical concern you have was not just that the speech could be used against your client, but that it was inappropriate for a lawyer who was speaking to the court to try to influence the court by going outside and putting pressure on it through speaking in the outside world. Even if it wouldn't hurt your client, it was still not an appropriate thing to do. I used to stun people. In fact, who knows if I was right? You guys can decide it. I refused to talk about a case while I was litigating a case, and these were usually cases of fairly high profile. I would not discuss the case publicly. And my position was, I'm a lawyer. I'm involved in the case. I'm litigating the case before a judge. My job is to talk to the judge. If I can persuade the judge, that's fine. My job is not to persuade the fuller society, because that would be trying to put pressure on the judge, and that's not the right thing to do. Now, I don't know that anybody believes that anymore, but I believed it, and I think you believed it, Paul. And I think that made us very, very reticent about speaking about things that we were intimately associated with.
Yeah, and the press was often very annoyed with me because I wouldn't talk about cases that we were litigating, and I wouldn't talk about cases that we weren't litigating because they'd say, I don't know the facts, so I can't have an opinion. But I will talk about general issues of law, and that was it.
Let me ask, how far down the line does this self-limitation of speech go? I mean, if it applies to a CEO or a board member, does it apply to a plant manager or a worker on the assembly line who says, I work for XYZ company and I really think whatever I think?
Well, I think everybody, it doesn't matter who they are, has an ethical duty to think about the consequences of their speech. If, for example, if the plant manager is going to speak about something to do with gay issues, and he's supervising gay people, I think before he says something or she says something, that she would have a perfectly strong First Amendment legal right to say, you want to think about what the consequences are going to be for the people who work for you. Or who have to intimately work with you every day. Now, again, I want to be clear. That's not a one-way street. That's just one factor that goes into the thinking about what the ultimate ethical balance will be about whether you should speak or not. But everybody has a set of a code of ethics that they should be living by, not just corporate presidents. And the factors in everybody's ethical balance are based on their life, who they are and who they intersect with. But everybody has them, and that they should be conscious of them.
I mean, yeah, I mean, suppose you're the plant manager of your largest auto production plant in the country, say for Tesla again. You get a call from somebody and it says, how's things going at the plant? Oh, we're busier than we've ever been before. Now, all of a sudden, you've got a source telling you that the largest plant for Tesla is producing more automobiles than it had before. That shouldn't be. He's not.
Yeah,
he's
but
giving.
that's
giving
inside
away,
information.
That's correct. He's giving away information that belongs to the corporation, and there you do have a legal duty. So it can be both ways.
What if that person says, I really think the president ought to be impeached because, and his work has nothing to do with impeachment or the company's production. And he's saying, I think the president ought to be impeached. And suddenly the administration gets angry and withdraws some tax credits that they might have otherwise.
Well, that would be a violation of the First Amendment, but it would be hard to prove. It would be expensive. You never know how these unconstitutional conditions cases are going to come out because they're so factually hard to establish. And so it may well be that the employee harmed the company in some significant way that way. And it shouldn't be that way. We should be able to enforce the First Amendment so that that kind of sanction doesn't occur, because that's illegal. The only question is it's expensive and doubtful about whether you can enforce it effectively. And does that then justify the company in saying, look, I know this was protected. I know it would be unconstitutional for them to punish us, but for God's sakes, will you shut up? Because we'll never be able to enforce the First Amendment. So please stop. And that I don't know the answer. I don't know. I think if it were me, I would probably keep speaking out, which is just because I feel that there's such a strong duty to express what you really believe in a free society. But I recognize immediately that it would be reasonable for someone to say, no, you can't. You have to stop.
I would simply add to that. Depends on the context, maybe. If you're standing in front of the Tesla plant with the Tesla sign behind you, that's one thing. If you're in a local bar, 100 miles away from the plant, and somebody interviews you and says, what do you think of the president? I think it's terrible. So I think it's a different context, and the connection between you and the corporation are very much more attenuated and unlikely to be an issue for the corporation.
Yeah, and Larry, it's important. I mean, you've made this distinction several times, and it's important not to lose it. If it's a private company, the decision about whether to fire the guy for making that statement is not a First Amendment issue. It's a private law issue as between the company and its employees. Over the years, I've argued unsuccessfully that it should be a First Amendment argument. I've argued occasionally, but with no real success, that corporations are such powerful entities and they exist only because the state says they can exist. I've argued that corporations should be liable, should be treated sometimes as the government when they censor the speech of their employees. But that's a losing argument. That's never gotten any traction. So that the real politic, the actual legal answer would be it's up to the corporation to.
Just one more thing. In a public company, if a board doesn't discipline in any way an executive who is, by virtue of speech, harming the company in a way that I've described, is the board liable for not disciplining that employee?
No, any effort by the state to stick its nose in here and tell the private people how they should decide these exquisitely difficult ethical questions. Any effort by the state to stick its nose under the tent and say, hey, I know this is a tough ethical question, but unless you fire this guy, you're going to be held responsible, and we're going to someone will sue you for damages. That's the imposition of a tort.
What if a shareholder filed a suit against the board because the employee harmed the company and the shareholder filed an action against the board?
Well, but the shareholder would have to have some sort of legal theory to win.
The legal theory is the stock went from 40 to 20 because we're
Well, but
selling half as
yeah,
many
well,
things.
no, that's just facts. I lost money. But why does the state say that since I lost money, I can collect it from someone else? They have to impose a legal duty in order for you to win the lawsuit. And if the state imposes the legal duty,
No, I'm not saying the state imposes it. An individual shareholder brings an action against the board and says, you are responsible for my losing all this money because by virtue of whatever the speaker said, the stock went down, cut in half.
well, but yeah, but if you're the judge, then you turn to him and say, well, now what legal rule is it that you want me to apply to give you any relief? And you would have to say that there's a legal rule in Delaware or whatever the governing state, a legal rule that says that if you don't act in the best interest of the corporation under these circumstances, you create a personal liability for yourself. That legal rule would be subject to the First Amendment.
Larry, you don't have an affirmative duty as a director to take action to prevent something. If in your business judgment, it doesn't require, don't forget, you have a great deal of latitude as a director under the business judgment rule. And you just simply can't have a situation where directors are automatically responsible for the stock going down. Nobody would ever be a director. I mean, stocks go up and stocks do go down. And so there is no causal effect necessarily between what the directors do and the directors don't do and the stock going down.
Yeah, let's push Larry's hypo. Let's assume that you can make the causal proof. That the economic, all the economic numbers are terrific, and there's absolutely no explanation for the stock going down, except for the negative public perception of the speech that is being made. I think even then you couldn't hold the board liable.
I agree.
Let me turn to Bruce Weber for a second. Bruce, you're a dean of an institution with more than 200 faculty members. What if one of your faculty members in the accounting area, nothing to do with politics, in the accounting area said publicly, I think this president should be impeached, et cetera, et cetera, et cetera. Would you admonish that professor in any way?
It depends on a lot of things, Larry, but the faculty are different than employees of a company, and we're a public university too. And CUNY has an academic freedom policy that's pretty clear about this, that faculty are entitled to speak on matters of public concern, public opinion. And the way I would approach it is, as long as what they were saying was legal and it wasn't crossing some boundary of incitement, we would say that that's the opinion of that individual and doesn't represent the institution or the Zicklin School of Business.
Okay.
And we'd be very reluctant, Larry, for the Zicklin School of Business to have an opinion on these things, because what is the Zicklin School of Business other than a group of faculty and our programs and students and staff and the advisory group that you chair? So it's something, I think we would not want to officially have a Zicklin position on some sort of a business or accounting matter.
Without having a position on it, would you go to the faculty member and say, hey, Charlie, I wish you would not talk about things like that. It doesn't help the school. We get grants from the state. I don't need all this.
Yeah. As you know, Larry, that used to happen when Abe Brillo was here and, was finding accounting questionable practices and often getting written up in Barron's for it, 30, 40 years ago.
I should tell the audience, we had an accounting professor who used to comment on what was in the financial statements of publicly held companies, and he would invariably get written up in Barron's, as Bruce points out, And he was always sued, but he always won. He always won. I want to push.
He was famous, and he lifted the reputation of Baruch, I think, for
Absolutely.
ferreting out these questionable practices.
Absolutely. I want to just get to one more place. 10 corporations now are responsible for almost 40% of the value of the S&P index. 10 corporations. This is more economic power concentrated in these 10 companies than I've ever seen in my lifetime. Do the CEOs, with regard to public policy, have to act differently because they've amassed such power?
Well, it depends on what you mean by have to. Should they? I would pose the question, should they?
I would
The
accept
answer is
your amendment.
And the answer is yes, they should. Because if you have a huge amount of power, you have to be even more careful as to how you use it. And that's a matter of certainly of personal integrity and ethics.
So there's a certain responsibility you have to society to exercise that power in some rational way.
Yeah, I think that's right. And I think the risk that we live in now that you've pointed out, Larry, these 10 corporations, they don't operate in some sort of vacuum. They, by the nature of the economic system we run, they operate in constant interaction with the government in some way. And the government becomes enormously important in whether they succeed and fail. And that, of course, then has a huge effect on whether ordinary people on Main Street succeed or fail. So they've now put themselves in this pivotal position where they're almost conveyor belts from the government to the ordinary person about success or failure. And it creates an entity that I'm not sure we've dealt with. I mean, these are the oligarchic entities, the entities that are massively important. Paul's absolutely right that the people that run them have to be self-conscious about the enormous power they wield, but I hope they're also self-conscious about their enormous vulnerability to manipulation by the government. Because they are so dependent on the government. And one of the things we're living through now is the excruciating decisions that many of the executives in these major corporations are making about whether to stand their ground and fight about First Amendment issues, or simply to say that it's, in the long run, better off for everybody if we pull back on what we believe and simply get along with the government in ways that allow the economy to thrive. And I mean, boy, I wouldn't want to be the guy that has to, or the woman that has to make that decision.
I just want to ask one last question. I'm sorry, Paul.
I said that's very different than what the law firms who have been sued by the government have done, and with the universities. I mean, these are critical key questions, and the people who are involved are large institutions. They haven't been picked because they're small institutions. They've been picked because they're very large institutions.
And it's at that point that the point I was trying to make earlier, that the ethics here are a two-way street. They don't only go in one ethical pulls you toward compromise, saying, my goodness, I don't want to risk these things. But the other ethical thing pulls you toward defending rights and values that are crucial to the society we live in. And having to make that balance between those two ethical norms strikes me as maybe that they are sitting in the hottest seat there is these days. The people that have to make that judgment.
And I hear your role as legal counsel to the ACLU in every word you said. Gwen, you have questions from our audience.
Yes, there are quite a few questions. What about the other side of the coin? Might a corporate leader be in breach of a fiduciary duty if he or she fails to speak out, if they believe that the government is coercing them to take a position they might not otherwise take? but for the government's communication to the company. So this is the opposite side of what you guys have been discussing.
Yeah, it's a great question. That's the point I just tried to make, that the ethics point in two different directions. This is not a one-way street. You may have an ethical duty to risk the company. You may have an ethical duty to fight for the values that the society stands by and lives by, and that would be destroyed if major companies just rolled over to the government all the time. And making that call is now, I think, maybe the single most difficult duty that an American citizen has.
Any other comments on that?
Well, I mean, I don't think you have an affirmative obligation. Fiduciary duty puts some affirmative obligation on you to stand in the way of the government shooting at you. Our society doesn't create that obligation easily. But there's no getting around it. These are very, very difficult times.
Yeah, I agree with you, Paul. There's no legal duty there. I mean,
Right.
This is not something that you can call up your lawyer and say what I should do. Paul will be the first one to say that the hardest questions that a client has to deal with are the ones for which there's no legal answer, and that the client then has to look inside herself and say, what kind of a person am I? And that some of these are those decisions.
And I would add to what Burt said, the hardest decisions I made in running a firm really didn't relate to advising clients. It was what I was going to recommend the firm to do in different situations.
I agree that I have the same, I was national legal director of the ACLU for many years. My hardest decisions were not legal decisions. In fact, the legal decisions were the easy, not easy in terms to execute, but easier in terms that I could go to sleep at night and not worry about them. I knew what I was supposed to do. But the hardest ones were.
Burt, can you tell our audience the Skokie decision that you advised the board of ACLU?
Well, that would be the paradigm. Of course, the ACLU is a nonprofit, so we don't have the issues that you have, but it's an organization of some importance in the society. It's was founded back in 19, and it tries to fight for the values of free speech and equality that are the bedrock of the society. And Skokie was a case where the Nazis were marching in Skokie, Illinois. And they chose Skokie because it was a community in which a number of elderly Holocaust survivors lived. They wanted to rub their faces in Nazism again. It was vicious and mean, but they had a right to march. The First Amendment allowed them to march, and we had to make a decision about whether we were going to defend the Nazis and allow them to march. And we all knew that we were risking the future of the ACLU, because people felt so strongly about this that we lost the Illinois affiliate. People just canceled their membership because they were so angry at us. But we thought that the ethics of standing up for what we believed was more important than taking a cautious position to protect the organization. And now I don't know whether that transmits to the marketplace. I mean, after all, the ACLU is an ideological organization, and if it can't be ideologically pure, then why should it exist? But it's a harder question if you're a corporate executive.
I agree. Gwen.
Another question that's kind of two questions along the same lines. Can the board of directors ever be obligated to silence or discipline a CEO? Or should companies adopt policies or guidelines for CEOs in terms of their public speech?
Well, I mean, we were talking before, for example, about if you believe you have a CEO who can't be separated from the company, so the board can't say that he doesn't represent company when he says something. Yeah, I think you have to have guidelines in terms of what he can say and not say. Otherwise, he can severely hurt the company. On the other hand, if it's Sidney Glotz, who nobody except Larry and Burt know, that you may not need to have the same guidelines. I think it's a very much contextual issue. It's not a legal issue. It's how you run the company. And if you're a company that is susceptible to having sort of bad things happen because your CEO says something, you've got problems.
Yeah. In your experience, Paul, how many companies have those kinds of guidelines?
Very few.
Yeah, that's what I thought. You think it's a good idea to have them in advance, so at least people have some sort of warning and guidance?
Well, I think it's a difficult situation, as all these things are. But we're in a unique period of time in my lifetime now, where the stance that a CEO takes can adversely affect the company to a degree that is vastly different than before. But I mean, we've had things before where companies' customers have divided hugely over things like the way in which a beer was advertised. And these would be societal issues. And I think in general, good CEOs know that on societal issues, they have to be very careful, because if they're a national company, their customers may divide 50-50 or something like that in terms of how they react to even an advertisement with respect to the company's products. So, yeah, you do have an obligation, it seems to me, a personal obligation to be careful of what you say in terms of your obligations to the company. But as I say, I think it's become substantially more acute today than it has in the past.
Yeah, I was thinking, Larry, when you were talking about Elon Musk, all I could think about was Henry Ford. My father would never buy a Ford, ever. And it was mostly because of the things that Henry Ford said and did when he was the head of the company.
Well, I have friends who own Teslas, and they have a sign in their Tesla that says, "We bought it before we knew."
Gwen,
We have time for one last question, and this one is for you, Larry. And this is not for you or Burt or Paul to speak as an attorney, but for you, Larry, to speak as a mentor. What advice would you give to our students as they're looking for entry-level jobs and when they are in the early years of their career, in terms of, expressing personal beliefs while balancing their professional and legal duties?
I would be very cautious about expressing my personal beliefs publicly. I would do it privately on every occasion. But I don't think any individual who's identified with a company should speak publicly about controversial items that would hurt the company, especially not voluntarily. Nobody asked you. Why do you have to do it?
All right, I think unless, Larry, do you have more to say?
Burt, would you disagree?
I don't know. I keep thinking, to thine own self be true.
Yeah, I thought about that.
No, I know. I mean, I know it sounds romantic, but after all, people exist as more than employees, and they have to have full lives. And I wonder what young people think about a world in which they're being told that they have to be very quiet about things that they care deeply about because of long-term economic and consequences. But I'm not sure. I don't mean to criticize it, Larry, because I think the decision is so hard. And the one thing I think we can all agree on, all the three alta caucus here, we can all agree that we'd rather be 85 than have to face what these kids are facing now. That is a hard. I have such admiration for the young people I teach, because they're so brave and they're so willing to get out and get their hands dirty in the world. And they face such a more difficult climate than the three of us faced when we graduated.
Yeah, I always remember what my father told me. I guess I talked too much as a kid. And I remember Pop saying to me, "You don't have to have an opinion on every subject." Gwen, I'm sorry.
Okay,
That was well-known advice for Larry. Your family wasn't the only one that gave that.
I want to thank you, Larry. Thank you, Burt. Thank you, Paul. Our next webinar on November 11th is Should Organized Markets Exist That Permit Betting on Nearly Anything and Everything? The guest will be Mark Edelman from our law department and his co-author, John Holden, who is professor of law and ethics at the Kelley School of Business at the University of Indiana. So again, I want to thank you, Larry. Thank you, Paul. Thank you, Burt, for a very engaging discussion.
Burt, Paul, thank you very much.